The common belief is almost universal. If you get pulled over and refuse the breathalyzer, you think you're outsmarting the system. No test, no proof, no DUI. And it's easy to picture the scene. You're sitting in your own car, the officer's flashlight in your face, and a little voice says, "Just don't blow." They can't force you. People actually believe that refusing the breathalyzer keeps their license safe. The reality is exactly the opposite. And it's one of the most expensive misunderstandings you can carry into a traffic stop. Because here's what most drivers don't realize in all 50 states. The moment you sign your name on a driver's license application, you've already given legal consent to a chemical breath test. Refusing it doesn't protect your driving privilege. It automatically triggers a suspension that hits you months before you ever see the inside of a courtroom. And if you confuse which test you can legally refuse with the one that comes with a hard statutory penalty, you're about to make a mistake that costs you your ability to drive. Drop your kids at school and live your life, all before a judge has even looked at the DUI charge. I'm going to walk you through exactly what really happens when you decline the breathalyzer, using a real-world stop that's been stitched together from dozens of body cam and dash cam recordings I've reviewed over 2 decades as a criminal defense attorney. In the first 60 seconds of the stop, it's a phrase that draws a bright legal line between the test you can refuse with 0 license penalty and the test that carries the automatic suspension, and using the wrong one could cost you your whole day in court. The body-worn camera footage starts like thousands of others. It's a little after 11 on a Friday night. The dash cam of the patrol unit captures the taillights of a silver sedan drifting slightly within the lane. Nothing dramatic. No swerving, no near miss. But the car's registration light is out, and that's all the officer needs. As the officer approaches the driver's side window, the timestamp reads 23:14:05. The officer's first words are friendly. "Evening license and registration. Reason I stopped you is your tag light is out. Have you had anything to drink tonight?" Now pause the footage right there. Is where the script gets flipped. Most people don't understand that the Fifth Amendment doesn't hibernate during a traffic stop. You are not required to answer investigative questions that are designed to build probable cause. Handles it calmly. On the body cam audio, you hear him say, "Here's my license and insurance." I don't answer questions like that. No attitude. No refusal to identify himself. Just a quiet, polite invocation of the right not to volunteer statements that can be used against him later. That exchange right there is completely lawful. The Supreme Court has been clear since Berkemmer v. McCarty that a routine traffic stop is a seizure under the Fourth Amendment. It doesn't strip away your Fifth Amendment right to remain silent about potentially incriminating matters. And notice what Alistair didn't do? He didn't lie. He didn't argue. He just handed over his documents and declined to engage in the fishing expedition. The stop takes the turn that teaches the lesson. The officer steps back, runs the license, and returns. The body cam jostles as the officer leans down again. "Sir, I'm noticing a faint odor of alcohol on your breath, and your eyes look a little glassy. I'd like you to step out for a few field sobriety exercises just so I can make sure you're okay to drive." The request sounds casual. It is anything but. This is the first critical intersection, and it's where the myth versus reality gap becomes dangerous. The exercises the officer is asking for, the walk and turn, the one-leg stand, the horizontal gaze, nystagmus test, those are field sobriety tests. And you need to know that they are completely separate from the chemical breath test that triggers the license suspension. If you refuse, field sobriety tests are physical coordination exercises that officers use to gather evidence of impairment. They are not mandatory anywhere in the United States. There is no statute that requires you to perform them, and refusing them does not by itself result in an automatic license suspension. That's a fact that surprises nearly every client I've ever sat across from. The United States Supreme Court has never held that field sobriety tests are compelled. They are voluntary encounters that the police offer as a way to build a case against you. And since the performance on those tests is visual evidence, the kind of evidence a jury watches on body cam video over and over, declining them is often the single best strategic move you can make during the roadside investigation. But here's where the language you use becomes everything. If you simply say, "I'm not doing any tests," the officer can and will write in the report that you refused all testing, including the chemical test they haven't even offered yet. That's the trap. So you have to speak with precision. What Ritor said next on that body cam footage is the exact phrase I want you to remember as the officer gestured toward the shoulder. Mike stayed seated, looked up, and said in a voice that was firm but completely calm, "Officer, I am not going to perform any field sobriety exercises. I am willing to take a chemical breath test, if required, but I am not doing roadside balancing tests." That sentence, word for word, is your legal firewall. It invokes your right to decline the voluntary coordination tests, while simultaneously affirming your willingness to comply with the implied consent statute that governs the actual breath machine at the station or jail. It removes the officer's ability to later claim you refused everything. And crucially, it's respectful. On the body cam, you can hear the officer pause for a beat, then say, "All right, I understand." Stack chant for people herstring here. There was no escalation, no forced removal, because Mike didn't give him a reason. He simply exercised the right that every driver holds. But the video doesn't end there. And that's where the real license consequence comes crashing in. After the refusal of the field tests, the officer had enough observations on the odor, the glassy eyes, the slightly delayed responses to form probable cause for a DUI arrest. And that's key. Refusing the exercises doesn't erase the rest of the officer's observations. It just means the state doesn't get the additional video of you wobbling on one leg to play for a jury. The officer placed Mike under arrest, read him Miranda, and transported him to the station. Then, in the breath test room, under the hum of the fluorescent lights and the recording camera mounted in the corner, the officer produced the official implied consent advisory form. And that's when Mike made the mistake that 1,000 body cam videos have recorded before. He refused to blow. The officer read the statutory warning aloud, the camera capturing every word. "You are required by law to submit to a chemical test of your breath. If you refuse, your driver's license will be suspended for 1 year. Will you take the test?" The officer didn't argue. He simply noted the refusal, and Mike was processed for the DUI and the refusal 24 hours later, before he had even hired an attorney. The DMV had already begun the administrative suspension of his license. Here's the legal reality that every driver needs to internalize. The chemical breath test, the one at the station, not the portable handheld unit, sometimes used roadside, is governed by what are called implied consent laws. Every state has one. The moment you accept the privilege of driving on public roads, you have implicitly agreed to submit to a chemical test of your breath, blood, or urine. When a law enforcement officer has probable cause to believe you're impaired, refusing that test isn't a clever loophole. It's a separate civil violation that triggers an automatic mandatory suspension of your driver's license. That suspension is administrative, not criminal, which means it's imposed by the motor vehicle department, not a judge. It can start as quickly as a week or two after the arrest. It requires no conviction. And in many jurisdictions, it lasts longer than the suspension you would get if you simply took the test and were eventually convicted of the DUI. In California, for example, a first offense DUI might result in a 4-month license suspension, while a refusal carries a 1-year hard suspension with no restricted license for the first several months. Other states tack on 6 months to 2 years. The punishment for refusing is almost always heavier than the punishment for failing the refusal as a void in the evidence. In most states, the prosecution of escalating can introduce the fact of a refusal as consciousness of guilt. The jury is told he wouldn't take the test because he knew what it would show. That's admissible. The Supreme Court addressed this landscape directly in that Birchfield v. North Dakota in 2016. The court held that states cannot criminalize the refusal of a warrantless blood test because blood draws are significantly intrusive, but breath tests are different. They do not implicate the same degree of bodily intrusion. So states may impose criminal penalties for refusing a breath test after a lawful arrest, and the administrative suspension of your license for that refusal is unquestionably constitutional. Birchfield blew apart the fantasy that you can just say no and walk away unscathed. But don't lose sight of the larger picture. What Kalon got right was separating the field sobriety tests from the chemical test. That single decision may have kept the actual DUI charge from being a slam dunk. Without the standard field sobriety test footage, the prosecution was left with an odor of alcohol, glassy eyes, and a registration light violation. That's a significantly weaker case. The refusal of the chemical test still hammered his license. But the DUI charge itself was eventually reduced to a reckless driving because the physical performance evidence that juries find so persuasive simply wasn't there. The license suspension was the cost of a strategic choice. He traded the field evidence for the DMV hit, and that trade is exactly what you need to understand if you ever find yourself in that seat. So let's harden this into actionable guidance. If an officer asks you to step out for field sobriety exercises, the law is on your side when you politely decline. You have no obligation to perform coordination tests on the side of a dark road. The exact words to say the phrase you can practice until it becomes muscle memory is a slight variation of what Mike used. Because it's that important. Officer, I am not going to do any field sobriety tests. I'll comply with the chemical breath test if required, but I am not doing roadside exercises. Write that down. That sentence invokes your right to decline the voluntary physical tests, while preserving your compliance with the implied consent statute that governs the breath machine. It's not a magic shield. The officer can still arrest you if other indicators exist, but it eliminates the visual evidence that often turns a borderline stop into a locked-down conviction. Once you are under arrest and transported here to the breath test location, you are in a different legal universe. The implied consent warning will be read to you. If you refuse at that point, the administrative suspension is nearly automatic. There are very limited grounds to challenge a refusal, usually tied to whether the officer had reasonable suspicion or probable cause for the arrest. And those challenges happen in a separate administrative hearing with a different burden of proof. So when the advisory is read, you need to make a decision based on your specific situation, understanding that refusal comes with a hard, immediate consequence to your license. While submitting to the test produces a number that might be used against you, but also might be challenged on calibration operator error or rising blood alcohol defense. There is no universal right answer, but there is a universal truth. Confusing the voluntary roadside tests with the mandatory chemical test is the most expensive mistake a driver can make in the first 10 minutes of a DUI investigation. And a quick but critical note on recording. If you find yourself in this situation and you want to preserve an accurate record, remember the First Amendment right to record. As long as you are not physically interfering with the officer's duties, you can keep your phone recording the interaction. The body cam is already rolling on the officer's side. Your camera can be your version of the record. In Mike's case, The officer's body cam captured the exact sequence that later allowed us to argue the DUI down. Your own recording can do the same, and case law from the 1st, 9th, and 11th circuits has consistently recognized the right to record police performing their duties in public. The takeaway from this roadside lesson isn't that you can outfox the system. It's that you can navigate it with clarity if you understand the two completely different buckets of testing. The exercises on the shoulder are voluntary. The breath tube at the station is a statutory condition of your driving privilege. Refusing the wrong one, or refusing both without knowing the distinction, sets off a chain of administrative consequences that arrive faster than any criminal charge and often hit harder than a conviction. The next time you see a body cam clip where a driver smugly declines everything and thinks they've won, you'll know they're probably looking at a 1-year suspension letter in the mail. Now, all of this assumes the officer had a lawful reason to make the stop and enough observations to justify the arrest. But what if the initial traffic stop was completely unsupported? What if the registration light was actually working? Or the supposed lane drift never happened? That's a different domino that can topple everything that follows, and I'll show you exactly how to spot an unconstitutional stop and what it means for your case. Next.